Hello, and we're looking at the tort of negligence. And the first thing to establish in negligence is that a duty was owed from the defendant to the claimant. Now, there are different ways of going about this. So you can have existing precedent, for example, those emanating from the Donoghue and Stevenson case. Then you can have like the Capara threefold test, which is applied to establish a duty. But then there's other types of liability imposed in law, such as the occupier's liability. That is basically if you have suffered some harm to you or your property on a premise, the occupier of that premise may be held liable if the following different components are satisfied. Now, there's two acts which regulate this duty. You have the 1957 Occupiers Liability Act and the 1984. The 1957 deals specifically with lawful entrance, whereas the 84 is more to do with trespasses. Now, we had a look at the duty of care that is owed to lawful entrance, and we looked at the fact that children are given a special kind of protection because they are vulnerable. The complete opposite to this is when you have skilled professionals. So section 2(3)(b) says an occupier may expect in the exercise of his calling will appreciate his calling of a skilled professional will appreciate and guard against any special risks ordinary incident to it. Basically, what this provision is trying to say is that if I call a particular builder or someone to do a specific job because there is a special defect or problem in the house to cure it, if that special professional gets injured by that, you can't blame that on the occupier because that was precisely the reason why they called you onto the premises. It's a bit of a circular argument, so it's only a logical thing. It's not even a special group. And we can understand this from the case of Rolls and Nathan, 1963. So basically, there was some dodgy fumes coming out of a boiler and two chimney sweeps, like in Mary Poppins we see. They were called to come and deal with this defective installation of the boiler. And I think they died, or they were seriously hurt. I think they died from the poisonous fumes. And here it was deemed that the occupier was under no duty of care to the two sweeps in regard to the dangers which caused their death. And this was said by Lord Denning. And the reason was because this was the exact sort of risk in which they were called to have dealt with and exercised their special skill and known to have dealt with. And this can be compared to, so for example, if you have a case where you have a dodgy boiler and you call the plumber and then the plumber dies from the boiler, then you can't blame the occupier. However, if the plumber came along and he stepped on the floorboard right next to the boiler to have a look at the boiler, and the floorboard was dodgy and it fell and he fell through the floorboard and died, I'm just imagining a scenario, then obviously you can hold the occupier liable because the plumber wasn't guarded against the risks of the floorboard. He was guarded against the risk that he was known and he had been called to guard against, which was namely the boiler. I hope this is making sense. And there are two more videos on the 1957 Act and the specificities it talks about. So we're going to look at warnings and how they're dealt with in this Act and independent contractors. Thank you for watching.